Distinguished delegates, ladies and gentlemen, we are starting our second day of this colloquium. I thank you all very much for joining online and joining in person. I'm very glad for the feedback we got after yesterday, where we had many very different, diverse presentations, and many of you wrote back to tell us how interesting it was. So we're really looking forward to having a similarly interesting morning session and afternoon. And we will reserve during this morning a session for exchanges of views by delegates of Working Group 2. So we had yesterday lost our connection with Yoshimi, Yoshimi Ohara from Japan, who was going to talk about witness examination, and it was supposed to dovetail nicely after the presentation by Sok-Chun Yoon on online hearings. So I give the floor now to Yoshimi so that she can give us her part of the experience of holding online arbitration proceedings. Yoshimi, you have the floor.
Thank you very much, Anna, for your kind introduction. My sincere apology, I was not available yesterday due to traveling. So, distinguished guests, ladies and gentlemen, it is my honor to be able to share my humble observation as to the need for witness examination protocol in virtual hearings. Next slide, please. Thank you. Yes, indeed. My esteemed colleague Sok-Chun Yoon nicely covered the virtual hearing protocol yesterday. And to follow up his presentation, I will focus on the need of witness examination protocol in virtual hearing. For that purpose, I will cover 4 topics. Number 1, witness examination protocol in physical hearings. Second, challenges unique to witness examination in virtual hearings. And third, for that reason, there is a necessity for witness examination protocol in remote hearings. And lastly, a reaction to witness examination in virtual hearings. Next slide, please. Thank you. So why witness examination, even in physical hearings, witness examination protocol is required even in the physical hearing setting? It is to ensure the integrity of evidence obtained by way of witness examination. And it is to ensure that evidence of witness is not influenced by any person other than the witness himself or herself, for example, through witness coaching. Next slide, please. So, common stipulation in witness examination protocol in physical hearings include having the witness use an unmarked set of document during the hearing. For example, even, witness himself, herself prepared witness statement. Witness statement, a clean copy of witness statement is usually given by a party cross-examining that witness. So that witness will not use his or her own copy with some notes or underline. Second, ensuring witness doesn't discuss their evidence with others like counsel during the course of examination, even during the break. And this is often implemented by the instruction of the tribunal to the witnesses. Next slide, please. So what are the unique challenges of with the cross-examination in witness hearing? So oversight of testimony becomes even more difficult in the virtual setting because witness is located in a separate venue and witness is visible only through the web camera, and anything located outside the camera's range is not captured by other participants of the proceedings, including the tribunal. Next slide, please. Therefore, there are greater risks of external influence over the witness testimony when witness examination is conducted virtually. For example, other witnesses, an authorized person may be in the room listening to the witness giving testimony outside a camera frame. For example, that unauthorized person may give a block sign to the witnesses, and thereby witness may be receiving cues from unseen person or device. There may be unseen devices recording the witness testimony. Next slide, please. So to address these issues, there's a need for witness examination protocol specific to virtual hearings. IBA rules on taking of evidence was updated in 2020, and Article 8.2 of IBA rules timely provides that where there's to be a virtual hearing, the tribunal should work with the parties to establish a protocol ensuring that witnesses giving oral testimony are not improperly influenced or distracted. Next slide, please. So some of the arbitration institutions have promulgated guidelines for examining witnesses during virtual hearings. These guidelines are not mandatory, but available for the parties to consider and adapt as part of the procedure for their own virtual hearings. Next slide, please. For example, ICC guidance note on possible measure aimed at mitigating the effects of COVID-19 pandemic 2020. In that guideline, parties are recommended to discuss and agree on modalities of virtual sequestration of witnesses and experts, whether someone else is allowed in the witness location to assist them with documents, for example, and also whether synchronous communication between the lawyers and witnesses is allowed. Next slide, please. HKIC also put together guidelines for virtual hearings, and HKIC in the guidelines recommended that presence of a hearing invigilator in witness room to ensure non-unauthorized evidence devices or persons are present. And also it suggested the usage of camera to provide 360-degree view of the room at the start of the hearing session to ensure integrity of the room. In fact, there's a hearing facility organized by JIDRC in Japan, and JIDRC is now offering a service of this invigilator. Invigilator means someone actually actually observe and witness how the witness is examined virtually. And also JIDRC offers this 360-degree camera to ensure the integrity of the room. Next slide, please. Thank you. SIC also put together guides, and according to the guides, witness should give evidence from behind an empty table to ensure no personal items present, and witness to remain in frame throughout the hearing session. And if they need to move off camera, for example, during break, party will need to consider how to manage this. And it also suggested the usage of 360-degree view camera at the start of the hearing session and after each break to ensure integrity of the room. Next slide, please. So you now recognize the challenges unique to witness examination in the virtual hearings. So you may wonder this virtual hearing will continue even after COVID. And interestingly, in spite of these challenges, reaction to witness examination in virtual hearings has largely been positive for various reasons. First of all, witness examination or virtual hearing in general is cheaper and faster and greener. Why? Because, the parties and tribunal members do not need to travel, which means, of course, there's no there's no, the parties do not have to pay for the accommodation or travel expenses. And because, virtual hearing can be conducted easily, it's easy. The arbitrators and parties are more flexible and more available in setting up the hearing date. That means, hearing can be conducted within a short period of time. Whereas when hearings are conducted physically, it takes more time to ensure that all parties can get together physically in one place. And because there's no flight, it's of course much greener. But in addition to that, some tribunal members appreciate the fact that they can closely see the face expression of witnesses through video. So, according to Berkeley Research Group, in Asia, up to 80% of hearings are expected to remain fully virtual well into 2022. And according to the study of 2021 study of Baker McKenzie and KPMG in the UK, 66% of participants in virtual hearings rated their experience as either good or excellent. So you can see that with virtual hearings and witness examination in the virtual settings will likely stay even after people may physically organize hearing. And therefore, we continue to need this virtual hearing witness examination protocol because as you can see, as you heard, witness examination in virtual setting has unique challenges, which will create the potential challenge to the integrity of arbitration proceedings and arbitration award, and it could increase the problem with respect to the enforceability of arbitration award. So there is a special need for the witness examination protocol when it is conducted virtually. As you have already seen, number of institutions have issued virtual protocol guidelines, but they are not necessarily identical, and there are good practice accumulated after this guideline has been published. So it is important to put together all those wisdom and create one single virtual hearing protocol to facilitate the use of virtual hearing going forward. Thank you for listening.
Thank you very much, Yoshimi, for your very detailed presentation and for highlighting for us what are the issues among which I understand the lack of harmonized procedures in these different protocols that have been put together by institutions as a reaction to the pandemic and the impossibility to have these witness examinations in person. So thank you very much. And with your presentation, we conclude the arbitration part of the DRDE project. And we will turn now to the mediation part, although we'll come back to arbitration a bit later. But we will start with mediation and with the changes that mediation procedures have encountered thanks to technology, to the role of technology, but also because of the impossibility to meet and to mediate in person. And I will pass the baton to my colleague, Jae Sung, who will be moderating this session. So Jae, over to you.
Thank you, Anna. As announced by Anna this morning, the intention is that we hope to dedicate the second half of the sessions, hopefully starting from noon or a little bit afterwards, to the working group looking at paragraph 17 of working paper 222, which sets out the scope of the stock-taking project. We have heard a number of presentations yesterday, particularly in relation to arbitration, but this session now will start with a perspectives on mediations, particularly our online mediations. First, by a presentation by James Claxton, summarizing the results of the Tokyo Forum, where we had discussed the topics of online mediations. And Karine would follow with sharing her experience as a mediator in the context of online mediations, and she'll also be happy to share her experience as an anonymous mediator, which will be also followed by George Lim, who will be providing an institutional perspective and sharing some of the case studies of online mediations. So without further ado, I would like to give the floor to James Claxton, who is ready online. You have the floor, James.
Thank you very much, Jay. Distinguished guests, ladies and gentlemen, it is my honor to be part of this discussion. Thank you to UNCITRAL for including me. The COVID-19 pandemic brought online mediation into the mainstream. I will use my presentation to provide a survey of some distinctive features of online mediation and good practices for parties and mediators when mediating remotely. To develop these points, I propose to share insights from a forum that took place last December, co-organized by UNCITRAL, the Ministry of Justice of Japan, and the International Center for Settlement of Investment Disputes. Three main questions framed discussion about online mediation at that event. The first was, how do mediators prepare for online mediation in a way that encourages successful outcomes? At the forum, Nadja Alexander spoke about the importance of trust between mediators and parties. Building trust may be less obvious online than in person. However, the convenience of online platforms makes it easier for mediators to meet with parties before a mediation for informal discussions. By the time that the mediation takes place, the mediator and parties will have had the opportunity to speak informally. This feature of online mediation, namely that parties and mediator can meet comparatively quickly and easily, has broader implications. In online mediation, mediators can break up a one-day mediation into a series of shorter meetings with one or both parties if that would advance the process. This might not be easy or even possible if the meeting had to be held in person. This possibility for asynchronous proceedings is considered by some to be a core benefit of remote mediation. Nadja also identified the importance of assuring that the platform being used is secure and that it is accessible, particularly to parties who may be less comfortable with technology. At the preparation stage, it is therefore important for mediators to advise parties about how to use the mediation platform and to have backup plans in case there are problems. The second question is, what are the comparative advantages of online mediation and what are its limits? At the forum, Bill Wood identified convenience, accessibility, and collaboration as comparative advantages of online mediation. Better collaboration may not seem to follow directly from meeting online. Yet discussing and agreeing on matters related to technology or to the online mediation process, such as the time of the mediation where parties are in different time zones, may give a sense of basic collaboration that can be built on. Concerning accessibility, in online mediation, participants are all equally framed in videos on a screen rather than spread out around a conference table at varying distances from one another. They may appear from home or other private spaces. These features may personalize the participants and facilitate dialogue between them. However, Bill also acknowledged certain limits of online mediation. A mediator trying to comfort a troubled or emotional party may feel constrained by the physical distance. Mediation on Zoom may also feel like just another Zoom meeting. By contrast, mediation in person demands a higher degree of commitment as parties must plan ahead and travel to the mediation venue. Mediating online also tends to be more tiring than mediating in person, requiring more breaks and shorter days. The third question is, how is procedural fairness safeguarded in online mediation? At the forum, Anne Karen Grill, who will speak today, distinguished between procedural fairness and the sense of fairness that is linked to the outcome of the process. Procedural fairness can be promoted in mediation through good process design and through good process decisions. For process design, mediators should, for instance, account for how information and documents will be shared between the parties and implement systems that protect data security. They should likewise ensure that the technology in use is user-friendly. For process decisions, mediators may, for instance, take steps that remove barriers to communication with the mediator or with each other. A fourth speaker at the Tokyo Forum, Wei-Ming Chuan, considered the role that dispute resolution institutions can play in support of online mediation. At the event today, you will hear from George Lim, chairman of the Singapore International Mediation Center, who will provide insight on the subject. For the purpose of this introduction, it is enough to recognize that institutions have a role to play in promoting mediation, including online mediation, and in facilitating the process. Online mediation is not receding with the pandemic. Anecdotal evidence and empirical evidence suggest that mediating online is as effective as mediating in person in terms of settlement rates. I commend UNCITRAL on the attention that it is giving to this topic in fora like this one.
Thank you, James. And Anne Green, you have the floor.
Yes, thank you, Jay. Good morning to everybody from Vienna. I would also like to thank UNCITRAL for inviting me to be part of this colloquium. And it is a real pleasure being here and to contribute to the DRD project. What I would like to contribute to this session today is to give you a practitioner's perspective on how online dispute resolution works behind the curtains. So for you to know, I'm an attorney at law, I'm a mediator, and I specialize in international dispute resolution. I work on commercial disputes, but also in ISDS settings. And as a mediator, I'm accredited with Cedar, the Center for Effective Dispute Resolution in London. Cedar has been a trailblazer in all things mediation, and this also goes for the field of ODR, online dispute resolution. So in 2020, Cedar set up a so-called platform to business panel, and I volunteered to participate in the vetting process to qualify as a mediator for that panel. And today I find myself amongst approximately 60 other ADR professionals. We are all experienced business-to-business mediators from across Europe and the United Kingdom. and we're all trained to conduct online mediations. We service over 20 European Union languages. And each mediator on the panel is appointed in accordance with the Cedar mediator quality commitments. That means each one of us conducts or observes at least 2 mediations per year. We undertake at least 6 hours per year of mediation-specific CPD, continued professional development. We're all covered with a professional indemnity insurance of at least £1 million, and we are monitored on a regular basis. That means we receive regular and independent anonymous client feedback after every mediation that we conduct, and there are really yearly reviews to the P2B panel of Cedar. That said, you will have to understand that what I'm talking about here is very dissimilar to the process that Professor Claxton just described to you. The Cedar platform operates on the basis of the EU regulation on platform to business relations, the P2B regulation that entered into force in July 2019. And this regulation is the first ever set of rules laid down by the European Union on the use of mediation to resolve issues between providers of internet intermediation services. We refer to these entities as online platform providers on the one hand, and their online platform business users on the other hand. The regulation seeks to create a fair, transparent, and predictable business environment for the use of online platforms. And on the other hand, it wants to ensure balanced and effective dispute resolution. Nearly half of the small and medium enterprises in the European Union use online marketplaces to sell their services. And there is an estimated 7,000 online platforms that fall within the scope of the P2B regulation. The regulation applies to all providers servicing businesses within the European Union and the UK, including post-Brexit times. And what you need to understand is that the term online platform provider under the regulation is defined very broadly. And the regulation explicitly mentions search engines, providers of online marketplaces, social media providers, and so-called app stores. Online platform providers who do not intermediate between businesses and consumers are not within the scope of the regulation. And as such, online advertising or brands selling their own products are not subject to the regulation. And with respect to dispute resolution and mediation in particular, platform providers are required under regulation to set up an internal complaint handling system and then name a minimum of 2 mediators who they would be willing to work and resolve the dispute. And where Cedar comes into play is the fact that in order to comply with the provisions of the EU regulation, the online platform providers can, instead of naming 2 mediators, also simply name an ODR platform provider, such as Cedar, in order to comply with the terms and conditions of the regulation. So, what does that mean in practice? I told you I am a mediator on the Cedar panel, and the panel, in fact, services ODR schemes that serve business users to escalate a complaint against an online platform provider that they work with. And as you may have noticed, I'm not mentioning any names here specifically, but after 2 years living through the pandemic, I'm sure everybody can do the math and figure out who the companies are that might be within the scope of the regulation. So that said, escalating a complaint means requesting voluntary and non-binding mediation or adjudication. In the ODR context that I'm referring to here, these terms are used interchangeably. And the business user who is promoting and selling their products on an online platform must first complete the internal complaint procedure provided by the online platform provider before they can start the regulation process. And usually this is an electronic process that commences with essentially the click of a mouse. It involves an advance payment by the user, and it also involves completing an online form. And this is basically an invitation to the business user to make available relevant documentation to explain their complaint. The mediator, who is then appointed to work in the background, because this is really an anonymous process from the perspective of the mediator, will make a decision considering the information that is provided by both sides. And the decision of the mediator will either be to make one or more recommendations for the online platform provider to take action, or alternatively, not to make any recommendation at all. What's essential is that the recommendation of the mediator is non-binding. And in terms of the case fees, what Cedar is charging is approximately 500 euros or pounds, depending where the user has its registered address, i.e. inside the European territory or outside. The case fee is usually split equally between the online platform provider and the user. And in the event that the mediator makes a recommendation, the user's portion of the case fee is returned to the user within 30 calendar days of the mediator's decision. Neither the user nor the online platform provider is obliged to use legal representation, although either party is free to do so if they wish. Each side must pay for their own costs of preparing the case. And by using the Cedar scheme, each party agrees not to take any legal action against the other party to recover such costs. What's also important to note is that any decision made by the mediator applies only to the specific dispute at hand, and under no circumstances does a decision made by a mediator create legal or any precedent. So with respect to the procedure, and I'm going to make this very condensed and short, if the Cedar receives an application, it will send a confirmation of receipt to the user who lodged the complaint, and it will also provide a reference case number. Upon receipt of the notification, the user has an additional 3 calendar days to make amendments and additions to their complaint, to their application, including the provision of additional evidence. Cedar then proceeds by making an initial assessment of whether the dispute falls within the scope of the scheme or not. And if Cedar considers the complaint to be valid, it will notify the online platform provider of the complaint and invite a response. Upon receipt of such response, Cedar will formally appoint a mediator to the case, and the mediator is then invited to issue a decision within a period of 40 calendar days, so slightly over 1 month. The mediator's decision will be set out in writing, and it will include reasons for the decision. A copy of the final draft of the decision will be sent to Cedar by the mediator for internal peer review. And only once the decision has passed Cedar's clearance, Cedar will provide it simultaneously to the user, the complainant, and the online platform provider. So with regard to the mediator has certain powers in that procedure. And the mediator also has certain obligations. So with respect to the obligations part, the mediator is required to be fair and unbiased at all times. The mediator is also required to act quickly and efficiently. And the mediator is required to issue a decision that is in line with the relevant law, with the relevant codes of practice between the parties, and any contracts that are in force between the parties. The mediator in turn has the power to change any time limits prescribed by the scheme rules. The mediator may request further evidence from the parties and set time limits by which these need to be supplied. The mediator must proceed with the mediation, even if the parties do not keep with the scheme rules or any instructions or other directions given by the mediator. And quite essentially, the mediator may also consult documents and evidence that the parties did not present. However, the mediator must tell the parties that such evidence has been consulted. And the mediator may also end the mediation if he or she is of the opinion that the entirety of the dispute falls outside the scope of the Cedar scheme. So, how does it feel to work as a mediator under the Cedar scheme? I received my first appointment in May 2021. So the scheme came into effect in 2020. I did my first case in May of last year. And to date, I have been appointed by Cedar on a total of 5 cases. So I can say I already have a small track record there. I have worked exclusively on the basis of the documents that have been provided to me by the parties. The only information the parties receive about me, their mediator, is what is available on the website of Cedar, and obviously what you can Google about me in the World Wide Web. The online platform providers were always represented by in-house legal teams. On the other hand, the users that I worked for, I have to say, in the Cedar scheme were only in one case supported by a lawyer. And even though the scheme rules give me the power to request additional information from the parties, I have not yet made use of that option. On average, with Cedar peer review included, I finish my cases very well within the 48-day time limit provided under the Cedar rules. Usually I work 1 to 2 days on a case. My work includes document review. Yes?
I'm sorry to interrupt you, but we are running a little bit late on time, so could you please conclude your presentation?
Yes, absolutely. What I would like to share is the following. It's not easy to work as an anonymous mediator in an ODR setting, a setting that is still in the process of growing, of developing. Being anonymous in the process is quite counterintuitive when you are a mediator and you are even used to working in online settings. So probably it would be wise to refer to that kind of work rather as adjudication than as mediation. And I want to alert the audience to the fact that even in ODR, there's no one-size-fits-all model. Mediators working in the background of online mediation schemes need to have an eye for detail. They need to have considerable experience to deliver within very short timeframes, and they have to have experience in essentially writing decisions. It's the proverbial blood, sweat, and tears, and it's still a people's business, even though it's conducted online. And I'll be happy to conclude here. I thank you for your attention, and I'll be happy to answer any questions that may arise in this forum. Thank you very much.
Thank you, Karin. I think we'll continue the discussions on the different dispute resolutions on the online platforms in this afternoon session today. but I'll give the floor now to George to give the institutional perspective of what kind of services are provided with regard to online mediations. George, you have the floor. And George, as we are running a little bit late on time, if you could limit your presentations to 6 minutes, that would be appreciated. Thank you.
Okay, I can't start my video. Jay.
We have you on the screen.
Yes, distinguished delegates and representatives, ladies and gentlemen, hello and greetings from Singapore. I chair the Singapore International Mediation Center, or SIMC for short. We are a not-for-profit organization focused on promoting mediation in cross-border disputes. I've been asked to share our experience in administrating online mediations from the institutional perspective. You know, 2 years ago, if you had asked me to mediate online, I would have expressed to you my reservations and probably resisted. However, the pandemic has forced us to learn new things and adapt. Based on SIMC's experience in the past 2 years and my own personal experience, I can now say with full confidence that online mediation can work and does work. You see this slide here. Thank you for showing that. This is a photo of what a hybrid mediation session administered by SIMC looks like. The photo only shows counsel and me, and this is to preserve the confidentiality of the parties. And this mediation was held at Maxwell Chambers in Singapore. Some of you have been there. Can I have the next slide, please? So let me share with you very quickly some of our statistics on mediation. Between June 2020 and December 2021, an 18-month period, 100 cases were lodged with SIMC for mediation. 89 of these cases have been heard, and 53% of these cases were conducted fully online or in a hybrid process, which means some parties come to the mediation session physically, and then some parties on screen. Now, of the online hybrid cases, 60% were settled. And from our perspective, this measures well with the overall settlement rate of 76%. I would now like to share with you 2 cross-border disputes which we help to administer. Can I have the next slide, please? The first case involved a dispute administered in a collaboration between SIMC and our Japanese counterpart, the Japan International Mediation Center. And for short, I'll call it JIMC. So this is very interesting because we have this joint protocol. Can I have the next slide, please? The case involved a joint venture dispute between Indian and Japanese parties. JIMC and SIMC each appointed a mediator. So we had a co-mediation. What was interesting was that JIMC appointed a Japanese mediator, and SIMC, we appointed a Singaporean mediator of Indian ethnicity. Okay. So this was to ensure that the 2 co-mediators understood the cultural nuances of the parties. The mediation was conducted fully online, and the parties settled after 2 days. SIMC and JIMC's end-to-end management ensured that the online discussions proceeded smoothly. Can I have the next slide, please? The second case involved a huge energy dispute involving 7 parties, which spanned across 5 jurisdictions: London, Geneva, Dubai, India, and Singapore. Of course, the facts of the disputes are confidential, but what was impressive in this fully online mediation was that it was arranged in less than 3 weeks and settled within a week. You know, considering the number of jurisdictions, participants, and time zones, this was a real learning experience for us and an eye-opener. Okay, can we stop the screen share? Jay told me to try and be quick. So in conclusion, allow me to share with you some observations and hopes. First, online mediation is here to stay, even after COVID-19. You heard a previous speaker talk about this in terms of virtual arbitration, and we think it's going to happen for mediation as well. Second, without the cost of travel, online international mediation is now so inexpensive, just a small fraction of litigation or arbitration costs. Add that to the fact that an international mediation can be organized within 2 or 3 weeks, as in the case I mentioned to you. It's actually a big change, and some people don't realize that yet. So what we are seeing now is more and more disputants turning to mediation either before or in the course of the adversarial processes. This is happening on the ground. Okay, so this is a trend I think we need to watch. Third, with this shift, my hope is that legal practitioners will increasingly see mediation as complementary to litigation and arbitration, and see their roles as dispute resolution specialists, helping their clients to resolve their disputes as timely and cost-effectively as possible. Fourth, mediation institutions play an important role in providing end-to-end support services for online international mediations. I think James alluded to this. This could include assisting parties to select the right mediator. Okay, this is actually very important, particularly where there are cross-cultural issues. It could also involve establishing electronic signature and document exchange protocols and ensuring the confidentiality and security of the entire process. And lastly, there's so much potential in online mediation. Leveraging on the Singapore Convention on Mediation, UNCITRAL can play a pivotal role in bringing governments, trade bodies, business organizations, and mediators together to develop this area to help businesses resolve their disputes quickly and peacefully. The world needs more peace. Thank you.
Thank you, George, for making a very concise presentations. I think the working group would notice that there are some commonalities that apply both to online mediation and online arbitration, but there are also peculiarities. For example, the environment that would ensure trust that is built between the parties and the mediators. So I think as the Secretariat undertakes the stock-taking activities, we will have to find out both the commonalities and the peculiarities that arise in the context of online mediation. So with that, we will close the discussions on online mediations, and we will have 3 different speakers on a slightly different topic. First, we'll be hearing from Camilla Mcpherson on what kind of how disputes are being settled in the financial sector and whether they have also deployed the same technology developments that we have seen in the context of general arbitration. Camilla, if you're there, can you please take the floor?
Thank you so much, Jay. I hope you can see and hear me okay. So I've been asked to look at how the resolution of finance disputes has developed in recent years. And this is a slightly different focus to some of the topics that have gone before. For one thing, I'm not looking at the detail of the process. But where I think it connects with the core subject matter of this colloquium is that developments in the resolution of financial disputes may to some extent serve as a model when it comes to considering dispute resolution in the digital economy, and particularly when it comes to dealing with the kind of cases that are going to emerge from technology, my interest being more specifically in fintech. So the starting point is that I have seen increasing institutional focus on this sector, and I'm going to look at a few of the reasons for this. I'm head of secretariat for Prime Finance. It's a not-for-profit foundation based in The Hague, which was founded in 2012 with a mission to ensure that the requisite expertise was available to address disputes arising in the financial markets. Prime Finance has a set of arbitration rules and a panel of experts in the field. And I believe it was unique at that stage in recognising that finance disputes were different and in particular would benefit from specialised arbitrators and mediators, and also from a process that was tailored to the finance market. Now, since 2012, a number of other initiatives have been launched focusing on finance disputes, including CTAC's financial dispute arbitration rules, the HKIAC's panel of arbitrators for financial services disputes, and that brings together a group with experience in hearing those disputes. The Central Bank of Egypt has recently been mandated to establish a new Egyptian centre for the arbitration and settlement of banking disputes. I recently heard of the Gujarat International Finance Tech City being developed as an international financial services centre in India, and this is going to include an international arbitration centre. And there may be more that I don't know of. And that's quite apart from court-specific initiatives such as the English Commercial Court's financial list. So what does this all tell us? Well, perhaps that prime finance is no longer alone in recognising the unique nature of finance disputes, but simply it's also seen as a good area for investment. So why is this? Well, the traditional approach on the part of banks has long been that the courts of the major financial centres, London, New York and others, are the best place to hear their disputes. And this has led to a reluctance to arbitrate. But it's pretty clear that that reluctance is now lessening. So why is this? Well, for starters, there's a greater appreciation that cases arising out of financial markets and complex financial products benefit from resolution by those who understand the area. And not every court system can provide this. We've also seen a huge adaptation of institutional rules in recent years to deal with perceived or actual shortcomings of the process, which might have put banks off arbitrating. I think the best example is probably banks often apply for summary or default judgments in the courts, and it's a quick way of dealing with a case. And traditionally, that has been a hard thing to replicate in arbitration. But a lot of institutional rules now include procedures that try and mirror those court processes, such as early determination of unmeritorious disputes, expedited procedures, emergency procedures. Another long complaint of the finance sector was that if you had lots of parties to a contract, and indeed lots of contracts, but part of the same package deal, it was very difficult to have everything heard in the one arbitration. But we've seen a lot of development of joinder and consolidation provisions in arbitration to help smooth those kinds of disputes. In addition, there's some of the well-known advantages of arbitration that become more relevant is the world in a global world where finance deals are involving more emerging markets and crossing ever more jurisdictional boundaries. And the neutrality offered by arbitration in particular is very appealing because it means that neither party to a dispute gets the home advantage of litigating in its own more familiar courts. And also, of course, there's the wide-ranging cross-border recognition and enforcement of arbitral awards under the New York Convention, which can make arbitration more appealing than litigation, particularly, again, where there's a cross-border element. Now, where I come back to technology and the topic of this colloquium is that what I also see is ever more potential for disputes in the sector. And I'm thinking really of the fintech sector. So fintech, without a doubt, is a fast-moving and innovative field. Law and regulation is struggling to catch up. You also see vast differences in approach from jurisdiction to jurisdiction. All of this leads to legal uncertainty, and where you have legal uncertainty, you will likely have disputes. And there are lots of reasons that I can see why arbitration will have particular appeal in the fintech field, and you'll be hearing more about that in other sessions coming up. So picking out just three, which really mirror the experience of the finance dispute resolution specialism. The first is expertise. Not many people really understand fintech yet. So it really is crying out for people who understand the sector to also decide the cases that are going to emerge. There's also great potential for expedition, and the fintech sector in particular calls for swift resolution of disputes. And finally, it's a new industry. So the traditional tie to the courts that I mentioned that banks in particular feel isn't there. And indeed, in some cases, fintech players actively resist established systems, and they would include in that established court systems. So what has held up the development perhaps of arbitration of finance disputes may not be the case when it comes to the arbitration of fintech disputes, because that traditional reluctance of the traditional finance actor just simply isn't there. All in all, this adds to both growth and opportunity in the sector. And in terms of where I think the future lies, I do think I'm in favour of initiatives, particularly that encourage the use of arbitrators who are specialists in the area of dispute. And with that, Jay, I'll close my words.
Thank you, Camilla. Now we'll hear from Federico on the term that we often hear on the website of blockchain-based dispute resolutions. And also he will be touching upon disputes that have anonymous parties, for example, those involving tokenized currencies. So Federico, you have the floor.
Thank you very much, distinguished representatives and delegates. My name is Federico Ast. I am CEO at Kleros, which is a blockchain and arbitration company. And we are pioneers in a new field called decentralized justice. Next slide, please. So since Zuckerberg changed the name of the company to Meta, we have become more and more aware that most of the future of disputes is going to happen on metaverse settings. Next slide, please. Different disputes will involve things like NFTs, the tokens, and decentralized finance. Next slide. And these disputes have a number of different situations that were not foreseen back in the day when the convention was signed. So it involves mostly digital goods. It's going to be about small claims in general. They will involve cross-jurisdiction situations paid by crypto. Enforcement of the rulings is going to be made by smart contracts in many cases. And this will involve anonymous parties and also anonymous arbitrators. And I don't want to even start discussing the possibility of some of these becoming like bots. Next slide, please. So the question that we have from the practical perspective is how can we resolve an exponentially growing number of digital disputes between anonymous parties in metaverse jurisdictions? Next, please. And there are like two main technologies that can be used. One of them is AI, which I'm not going to review now because it's going to be discussed by other people. And the other, which is where I work, is called Decentralized Justice. And it is the use of blockchain game theory to produce new sets of incentives for humans to arbitrate disputes. Next slide, please. So let me show you a short example of how this works. You have like Alice and Bob. Alice, she hires Bob to do a video for her on an online platform. And she doesn't know who he is. I mean, they are both anonymous. They just interact through avatars and they make an agreement. Next, please. And there is a dispute in this agreement. And well, because she claims that the video he developed for her is not the quality she expected. Next, please. And of course, she's not going to go to arbitration and the Paris Chamber of Commerce to resolve a claim of a small claim of $500 or $1,000 with an anonymous party. It's just not efficient, and it's not clear what she should do or how she would start on this situation. Next, please. So now let's imagine that she instead of paying the contractor directly, she makes a payment into a smart contract, a blockchain smart contract, and they both agree that if there is a dispute, it's going to be solved by an arbitrator called Kleros. If there is no dispute, she releases the payment, all's good. And if there's a dispute, the funds are going to be locked into this smart contract that acts as an escrow. And this is going to be sent to Kleros to make a decision on this case. Next, please. So Kleros is a blockchain application that is using based on the Ethereum blockchain, and it will select a number of people, of jurors who are going to assess the evidence. They're going to evaluate the contract. They're going to evaluate the agreement that was done and the product, and they're going to, each of them independently vote on who is right. Very important why Kleros is built on blockchain, because it makes sure that no one can tamper with the evidence and that no one can tamper with the jury selection process. So not even the founders of the project can change anything that is written in the code. And this will give parties the full certainty and trust that they can use this type of system. Next, please. So these jurors vote on the case, and then let's say they vote for Alice, so the smart contract releases the payment to her, and so this solves the situation. Next, please. So a big innovation of how Kleros works is that juries are anonymous, right? And they have to be selected in order to be a jury. You have to buy a crypto asset. It's PNK is the name of the asset in Kleros. There could be others in other platforms, which is like a lottery ticket that gives you the right to be drawn as a juror in claims happening in the platform. Next, please. So you want to be a juror, you deposit the token, let's say, in this court that specializes in video production cases, in this case. And then of all the people who deposited the token into this court, a number of them are going to be drawn randomly. Next, please. Next, please, again. And so let's say the platform draws 5 jurors, and these are the guys who are going to resolve the claim, and they're going to vote. And again, these people are anonymous. Next, please. And I don't have much time to go into the game theory behind this, but the main idea of decentralized justice systems is that it can produce a number of incentives for these users to adjudicate disputes in an honest way. So if you are not honest in how you make your decision, you are going to probably lose money. And so what does it mean to be dishonest? Just to decide disputes randomly, or to take bribes, or any other behavior that is not honest. So next one. And users that behave honestly, they are going to be earning money as they will be resolving disputes. And so that is how the platform balances the incentive. So there's a lot of game theory behind this, and it's hard to explain very fast, but there are lots of videos where you can see how this works in practice. Next, please. And another one. So the way we think about the future of dispute resolution in this context of the metaverse is that there's going to be resolved by 3 main situations. So for the cases which are more objective and less complex, they're going to be fully automated by some AI tools. And this is okay because this is cheaper and that works. But there's going to be then some cases that are still small claims of cross-jurisdictional and all that are too complex to be resolved in a fully automated way because they involve some situations that machines are not very good at resolving, like situations involving humor, sarcasm, and agreements between people that require humans to be resolving. So this is going to be where the centralized justice systems are going to be better for resolution. And then more complex cases are going to be resolved.
Ich bin zwar in einer Online-Konferenz, aber ich muss jetzt gerade nicht sprechen. Ich habe meine
Okay. And more complex cases that require multiple parties or more sophisticated legal understanding, they are still going to be resolved through traditional means of online dispute resolution. And the thing is that AI and centralized justice seem to not fit very well with the traditional ways of the New York Convention as a due process, right? Next, please. So a big question I think that we will have to resolve and to discuss in the context of UNCITRAL is, what does due process look like in the metaverse? In the situation, next please. In a situation where we have anonymous arbitrators, where agents could be a party and an arbitrator, because a party, since it's anonymous, could have another account that arbitrates the dispute where it's also a party. We will have to discuss if these new types of incentive systems can be applied and if they can be integrated into the legislation that we have for resolving disputes. And what happens to judicial review in situations where the enforcement is done by a smart contract and there's no need to have a state court decide a ruling. I mean, once the smart contract receives the decision by the arbitrator, then it just enforces the decision. And this is not something that was thought about when we built the New York Convention. Next, please. So I think that one of the main takeaways I have for this session is, well, we have this new breed of disputes. Maybe we need a new New York Convention that is able to address a number of situations that nobody thought about in the 1950s when the New York Convention was signed, nor in the jurisprudence that happened after this. Next, please. Because what we have now, the situation is that we have an exponentially growing amount of cases that happen in this metaverse jurisdiction. And the systems that we have currently for resolving them don't scale as fast as this number of cases that we are seeing and that we're going to see exponentially grow in the future. This is going to create a justice gap that is going to be larger and larger as times go by. Next, please. And the idea of trying to implement these new systems is to scale up also the capacity of resolving dispute, evolving AI, decentralized justice, and the other ODR methods. Thank you very much for your time, and hope you find this interesting, and let's discuss this further.
Thank you, Federico. I think you were able to give us a view of the changing landscape that we are facing ahead of us, and I question whether an award in the metaverse is a foreign arbitral award, whether it's a different award, and also whether the New York Convention would actually be relevant if the smart contract is used for enforcement at all. So the last speaker for the sessions that we have devoted to DRD is Professor Koutoumi, Charles. Yesterday, we did touch upon the fact that the use of technology in the arbitration is quite different from that has been used by the courts, and how to transfer the information that was produced in the arbitration process to the courts was a question that was answered. But Professor Koutoumi would address the judicial assistance that is to be provided within the context of DRD, in particular with regard to interim measures and in relations to asset tracing, and hopefully how these things could be coordinated among the different courts. So Professor Koutoumi, you have the floor.
Thank you very much to everyone for inviting me here today. I was a private arbitration counsel for nearly 20 years as a partner at Jones Day in Washington, D.C., and now I'm a full-time academic at the University of Pittsburgh School of Law. And so I've been asked today to talk about something that is both practical and academic, and that are interim measures in a global digital economy. The concept of asset tracing it's a very hot topic today in international dispute resolution, right? We can't turn on the TV or open the newspapers unless we hear about freezing and seizing yachts and London penthouses. And it's become an important topic for lawyers and lay people alike. And those discussions reveal two things. One, it's a potent tool in international disputes. And the other thing is it's not that simple. And the difficulty is sometimes legal and sometimes practical. When it comes to currency, the transfer of assets quickly across jurisdictions is far easier than it once was. Catching those transfers in a digital economy when a debtor wants to be obstinate is very, very difficult. And when assets are digital currency that we just heard about, or other digital assets, reaching them becomes even harder. Even the ownership of real property can pass quickly through tiers of offshore corporate entities, making freezing and seizing a real practical challenge. Now, UNCITRAL Working Group 5 dealing with insolvency has been out in front of this. There, the United States has urged the creation of additional multi-jurisdictional tools to counter a debtor's ability to transfer assets quickly and frustrate arbitration and litigation. The colloquium resulting from that invitation identified the main legal gap being the cross-border recognition of judicial decisions pertaining to civil confiscation and freezing orders, and this is a judicial gap. Now, this working group should be part of that discussion and part of that solution. Insolvency doesn't have a monopoly on this sort of relief or the necessity for it, nor do domestic courts. Surveys have shown that the parties in search of interim asset preservation in disputes are often before arbitration tribunals and not domestic courts. Now, the power of tribunals to issue this sort of relief isn't in doubt. A decade or more of work by this working group in the early 2000s made sure of that. Under Article 26 of the UNCITRAL rules, as we all know, tribunals have broad authority to issue interim measures, including asset attachment. And the UNCITRAL model law on international commercial arbitration allows interim measures to be enforced, both in courts at the seat of arbitration and elsewhere around the world. Now, UNCITRAL has taken the view that the widespread adoption of the model law would produce the same effect as a multilateral convention on recognition and enforcement of interim relief. But despite the permissive infrastructure and widespread adoption of the model law that we have, progress on the global circulation of these sort of orders has been relatively halting. Some jurisdictions persist in maintaining that only final awards on the merits can be judicially enforced under the New York Convention. Some will only enforce interim measures issued by local tribunals. Many still refuse to enforce in personam interim measures to enjoin party conduct, such as anti-suit injunctions. Now, if the objective here is the global circulation of interim measures, we are not yet there, and this speaks nothing of the need for improved efficiency and speed to adapt to the digital economy. So what can we all do? What can this working group do? One thing it could do that I think would be very academically useful and very practically useful for counsel and arbitrators is to create a toolkit for counsel and international arbitration tribunals to formulate their interim orders that have the highest likelihood of recognition and enforcement around the world. Consider a recurring and problematic hypothetical: a tribunal seated in one state, arbitrating parties from two other states, liquid and movable assets held in third, fourth, fifth, and sixth states, and a debtor capable of moving them quickly between them. The uncertainty regarding the enforcement of arbitral interim measures in this scenario partially lies in their near limitless breadth. Tribunals can order parties to really do anything that might upset the status quo, from issuing in personam anti-suit injunctions to more simple orders freezing assets in rem. Now, under the patchwork quilt of domestic laws, the former still often go unenforced, but the latter are remarkably and relatively non-controversial. The provisional attachment of a defendant's assets in rem, which is allowed by Article 26 of the UNCITRAL rules, is recognized and enforceable in nearly every jurisdiction around the world. Now, we can build off this congruence. A working group toolkit could include a comparative study of domestic treatment of various forms of interim relief. For example, tracing which countries will enforce in personam measures and which limit them to in rem, which countries will enforce interim measures from foreign seated tribunals, and which limit them to locally seated tribunals, and the form of interim awards and various other nuances in the domestic laws that may stand as obstacles to free recognition and enforcement worldwide. The goal could be to provide accessible guidance to counsel and tribunals on what types of interim relief are most likely to garner recognition and where, and to encourage counsel and arbitral tribunals to use the least controversial forms of relief. And lastly, to identify and fix small nuances in domestic laws that may create an obstacle. This would dovetail a bit with Working Group 5's efforts and provide another tool to adjust international dispute resolution to the global digital economy. Now, in the very, very short time I have left, I want to provide some long-term thinking. This is a toolkit like this can be very useful as short-term assistance. But I think ultimately we should be thinking about a treaty-based solution to the cross-border movement of interim measures of asset attachment. The solutions that were adopted in the Hague Choice of Courts Convention could be a useful starting point here. Now, that convention, as we know, carves out interim measures of protection from its purview. But using what they have there as a framework on jurisdiction, recognition, and enforcement, and applying that framework to in rem attachment orders, where there is remarkable global congruence, could lead to a new additional tool to counter an obstinate debtor's ability to transfer assets quickly and help reduce the cost and time to recover such assets. Now, this is long-term thinking for sure, but the ability of arbitral tribunals and domestic courts to freeze and seize assets in a fast-moving global and digital economy is crucial to the practical growth of international dispute resolution processes. And filling this interim measures gap in the Hague Choice of Courts Convention, I think could be a useful long-term exercise. Gone are the days when asset preservation can focus on one party, its one bank, in its one home state where the arbitration tribunal is seated. Dispute resolution has to keep pace with the hyperconnectivity that results from billions of everyday online interactions among people, businesses, devices, data, and processes, intricate corporate structures, and highly mobile assets. This means that working towards greater congruence in practice, greater uniformity of process, and greater reciprocity of result in tracing and recovering these movable assets could be really beneficial to the growth of international dispute resolution, arbitration, and litigation in a digital world. Thank you.
Thank you, Professor Kutubi. As I continue to work on enforcement of security interests, also in the topic of digital assets, this is kind of it shows how interdisciplinary the working groups need to be in the context that we are talking about dispute resolution in the digital economy, but how these resolution mechanisms can be used to enforce other proceedings, for example, insolvency proceedings and security rights. So I think this shows a good highlight of how UNCITRAL as a whole should also coordinate its work. So with that, I would like to draw your attention again to paragraph 17 of working paper 222. We have tried to give you, we have invited speakers to provide you the changing landscape of the dispute resolution in the digital economy. We have tried to highlight the developments that are taking place. And we have also received suggestions on future work by the UNCITRAL, providing guidelines on online arbitration, online mediation, providing protocols on online, the conduct of online hearings, also on mediation as well. We've also noticed that there was a call for rethinking the New York Convention in the metaverse, and also the most recent proposal by Professor Kutubi to address asset tracing and interim measures coordinations between judiciaries. But in order for the Commission to make an informed decision on the future work, we have the mandate, and the Secretariat has, the Commission has asked the Secretariat to take stock of other developments. And in paragraph 17 of working paper 222, we have outlined the different areas that we would need to take stock of. Of course, some of them were discussed by the speakers, some have been elaborated by the speakers, but we would like to get inputs from the working group delegates and the public, whether the scope of our work that is to be conducted in the next few years is appropriate. Is there anything that is missing from the scope that needs to be added? Or are there things that need to be taken out because it does not fall within the mandate of the UNCITRAL and its working group? I just wanted to highlight that there are 5 big points highlighted in paragraph 17. One relates to the constant arguments that were made that we have to ensure equality and fairness, issues arising from the use of technology while balancing the efficiency, which was also highlighted by the delegate of Israel yesterday. We also have to address the flood of information problem, that there is different, the parties and the tribunal may have different access to technology, which may raise this flood of information problems. The appropriate use of dispute resolution on online platforms. Of course, we'll be having a more detailed discussion on this in session 4, but there was a reference to consumer disputes today. Also, a reference was made to small claims that disputes that arise, and whether such proceedings in courts should guide our work. And we have heard about a lot about online hearings and witness examinations, and whether our work should be conducted on developing a protocol that would guide the arbitral tribunal and the parties in the conduct of such hearings. And lastly, this morning we heard about the different standards and protocols and guidelines with regard to online mediations and how they need to be developed, particularly in light of the peculiarities that we have on mediations. So that is kind of the broad scope of stocktaking that the Secretary will be undertaking in the next few years. And then based on that information, we would like to provide that information to the Commission as it makes a future its decisions on its future work in the field of dispute resolutions. With that, Anna, would you like to say anything at this point?
Thanks very much, Jay. I think we can now open the floor for inputs, reactions, views by the delegates to this working group, whether online or in the room. And as Jay mentioned, we are really focusing this discussion on the various elements for this stock-taking exercise, the stock-taking review that the Secretariat is undertaking already, and with a view to identifying if all these points that we have listed in the working paper 222 are the right ones, if there are others that need to be added, and hear your reactions to all the extremely challenging and interesting presentations that we have heard so far. Thank you very much. The floor is over to anyone who wants to take it, please.
Just to add to that, there is also a question about the form of how the stock taking would take place. Of course, this would be something done by the Secretariat, and we would have to provide the information to the Commission. But as there have been existing informations, we have heard from a number of organizations, the ICC, the IBA, ICA, has the information that relates to DRD, which we also hope to compile and also share with the Commission, but also to the public community as well. So as we proceed with the stock-taking project, we'll also need to think about how to process the information and to present it more generally. So if you have any comments on that, that would also be appreciated. Thank you. And then I would like to give the floor to the delegate of Singapore. Thank you.
Thank you, UNCITRAL Secretariat, for organizing this colloquium. We have listened with interest to the excellent presentations that have been made so far. The Singapore delegation is supportive of these stock-taking efforts to study what can be done to support the DRDE work, including any further work to develop guidelines or legislations, if so required, in particular to ensure that there is equality and fairness in using technology in dispute resolution, to preserve the integrity of online hearings, document exchange and witness examination, and more generally to promote greater use of technology in dispute resolution. As an international dispute resolution hub, Singapore is pleased to contribute to the discourse on these topics and to contribute through sharing the experience of our Singapore-based dispute resolution institutions and practitioners in this area. This includes SIAC and SIMC, which have earlier shared at this colloquium their experience and best practices in administering disputes using technology and online platforms. Thank you.
Japan.
Thank you, Jay. I was dithering a bit whether I should take the floor now or later, but I have taken the floor, so I will share some observations. One of the basic good that stock taking should bring is the sharing of best practices. Speakers and representatives have touched on the issue of digital divide and the divide between the developed and developing countries. And we are of the view that stock taking may help to address that. But we think more could be done through stock taking, listening to the great discussions which took place yesterday and today with distinguished representatives and distinguished speakers. It seems that work on some topics put forward in working paper 222 to be carried out as part of the stock taking may be developed as a secretariat paper on possible future working group 2 work, which will provide a basis for discussions on future work at future commission sessions. In abstract terms, this would likely depend on the ripeness and nature of the various topics. For example, on online hearings and witness examination, we have heard institutions and practitioners share their extensive experience and insights on the topic. The distinguished representative of the United States and several other representatives suggested that notes may be the preferable form of work, whereas some other representatives express preferences for guidelines. With respect to the issue of the flood of information, the distinguished representative of Israel shared with us rules and practices that have evolved in dispute resolution mechanisms in Israel and suggested that research may be carried out in various dispute settlement mechanisms, jurisdictions, and legal systems. Reference was also made by the distinguished representative of Singapore to SIAC's experience. Mr. Toby Landau discussed the need for a shift in the context of increased digitalization to address redundancy in proceedings. Also regarding the judicial assistance, which was discussed in the context of interim measures by Professor Kutubi, the discussions were suggestive of possible legislative work. I have not touched on the issue of online mediation and also the quality and fairness issues arising from the use of technology, but I'm not suggesting that they are less significant, but rather they are equally or even more important. But I will leave time for perhaps other delegations to share inputs on other important topics as well. And this is all I have for now, and I very much look forward to exchanging views with other distinguished representatives. Thank you.
Thank you. I would like to then give the floor to our Spanish delegate, Carlos.
Buenos días.
Good morning, good afternoon, good evening, everybody. I hope you can all hear me. At the outset, then, in line with distinguished delegations speaking before me, I should like to start by congratulating the Secretariat for this wonderful and very interesting event that you've organised, which is of real complexity as well. We've gone for a session and a half so far. We've clearly seen that. So the Secretariat is asking us about our positions on these proposals, which we see in paragraph 17. And these proposals are going in the right direction from our point of view, clearly. However, in a session and a half, we have been able to observe the existence of multiple problems which will then have an impact on our possible responses. So the multiple use of technology is one of these. And there's a concept of support which was previously done manually or else autonomously, with results now which will also then be autonomous. And this then raises the issue of what role such instruments or platforms will play. Will this be a decisive role? Will it be as an independent third party? Will these be merely support systems? And in all these cases, as the delegation from Singapore was saying, who spoke previously, these are all underlying all of this are questions of due process and traditional questions which now become even more important regarding data, documents, accessibility of the platforms, previous and posterior hearings with regard to the use of the platform, the control of algorithms which may be used, and gender, race or geographical origin elements. So we need to focus on some of these problems, and the first point is the very concept of the institutions that we'll be using as mediators. Mediation is what is said in the UNCITRAL text of a third party who helps parties to autonomously reach a decision. Or, on the other hand, is mediation something which is offered in a specific way by a specific third party after having heard the parties? There is also the fact that some of the disputes which arise, and I'm looking at today's session, they're very low in number, and they look at consumption, for example, where the parties are on an unequal footing. So there may be a cyber arbitrator or a cyber mediator who can act in an autonomous way, but this is no longer an impossibility, this concept, this idea. And so as I stress, fully support the work of the Secretariat, as does my delegation, and I mean also in line with the philosophy of what previous delegations were talking about yesterday. The debate which we are beginning at the moment is not just about what we want to regulate and on what, mediation and arbitration are two different things, but we also want to look at how we do that. This is moving very fast. We need to look at the applicability of the UNCITRAL's text to this new reality, and perhaps whether, in line with the questions in paragraph 17, the task of UNCITRAL could be very important indeed, in that it's both didactic and as a regulator, and could be done through protocols, guides, toolboxes or similar, which will allow us to underscore existing problems and put forward proposals to resolve these so as to generate security. Thank you very much, and I do apologise for speaking at some length.
Thank you. Next on the list is the delegation of Israel.
Thank you, Jay, and thank you also to the presenters of today, which were also very interesting, like yesterday. A couple of points maybe to add to what we said yesterday in light of today's discussions. We think that amongst the issues that could be added or could be emphasized, to the list is the question of witness examination. We also think that it would be important and interesting to do a stock-taking exercise on how, especially on how measures are taken, and which measures are taken to avoid manipulation or witness tampering, which we think that should be the focus of work on this issue. In respect of the new proposals that we heard today, we would support exploration of work on judicial assistance to arbitral tribunals, which we heard, I think, in this time, and also maybe in the commission session, that for some delegations this is important. We would also support work on interim measures, but in that respect, we would prefer to, we don't have a problem with stock taking, but before we decide on anything normative, we would be, even if for a toolkit, we would suggest to wait and see the outcome of work in Working Group 5 to see whether that was a good exercise there or how it was, what kind of issues came up, and this will help us in consulting internally. In respect of suggestions that we heard, I think in this morning, some suggestions to amend the New York Convention or to have a new convention on interim measures. Even as a stock-taking exercise, we would really caution against this. We would not see this as a useful resource dedication by the secretariat. On both counts, we think it will be a hopeless exercise. We know that there is already a convention on asset recovery, in the United Nations Convention Against Corruption, and there are a lot of issues that come up with that, although that probably did somehow improved the matters, but it also brought up a lot of controversial issues and sometimes used not in the correct technical intention, we think, of the drafters. So we would see that experience as a rather negative one, and we would not want to go down that route. But again, we don't have a problem with stock taking and for the Secretariat to compile practices, but that should be the aim. And as for the matter of format, we think very much like what Distinguished Delegate of Japan mentioned, that the result could be in the form of Secretariat papers, maybe not for this commission, maybe it's too soon, but for the next commission or the commission after that. And then we can see what can be done. So we would suggest, however, that the next papers will try and be a bit more focused, and so that we would really see what are the top, 2 or 3 issues that should be discussed. This would make it much easier also for us to consult internally. Right now, when we show this kind of document to colleagues, it's very hard to get responses from them because it's so wide and so verified and so diversified. So hopefully the next papers will be a bit more focused so we can, in light of the discussion here, so we can have better internal consultations. Thank you.
Thank you. Next on the list is the delegation of United States.
Thank you, Secretariat, and again, thank you to the presenters for today. They were all very helpful and thoughtful presentations and have definitely given us some food for thought. With respect to the questions that you've posed, in terms of the categories that are listed for stock taking, and as we mentioned yesterday, we think that the pursuit of the stock taking is a good exercise. It does seem that a number of them may lend themselves to guidance as opposed to something legislative necessarily, because it's hard to see where harmonizing can be done effectively and efficiently without ossifying the process. I think of the image of a cat chasing a string that's being pulled. Even when the cat catches the string, sometimes the string gets pulled further. So we don't want to be chasing the ball, as it were. But I do think that these categories are good for staying on top of the developments and seeing where they go and where harmonization may be necessary. And some of them do influence one another. For example, questions about the procedures of online hearings and witness examinations may play into the equality and fairness of proceedings themselves. In terms of what might be missing, though, I think we heard in the last presentation by Professor Katubi that one of the challenges that we are seeing is that traditional arbitration seems in general to be able to adapt to the digital economy, but that there are aspects where our existing tools either need perhaps guidance or clarification, or perhaps some normative suggestions on how to strengthen them. And I think about the enforcement of interim measures, which is obviously a part of the model law and is available as a tool, but how it can be strengthened to adapt to the speed of asset movement. And while that is related to asset tracing in Working Group 3, it's more of a specific element of what is available. So I wonder if there isn't an additional category, and it also might preview some of the topics that we'll be looking at later in the week, that are there aspects of the digital economy that require us to look at our rules and legislative instruments as opposed to whether or not the rules themselves are responding adequately to the digitization of arbitration. Thank you.
Thank you. I just wanted to clarify that as part of the stock-taking project, we would not be suggesting topics themselves. We will be taking stock of the developments, and then possibly it will be the Commission that would be thinking about the different proposals. Because yesterday there was also on the requirements for a physical hearing, there was a proposal that we may need to clarify the meaning of hearings in Article 24 of the model law. As we look into the different issues of online hearings and we take stock of the different legislative responses by the different jurisdictions, we may come to the conclusion that we may need to provide more clarifications on the existing UNCITRAL text. So I just wanted to clarify that the proposal for future work is not our job. It will be for the Commission to take a look at the stock taking, the information there, and then to make proposals themselves. The next on the list, we have Switzerland, France, and then the United States. But would you like to respond first to the United States?
Yes, thank you for letting me have an interaction. I appreciate that. Just to be clear, we weren't necessarily we're not proposing a specific project. We appreciate that will come is something that will be done before the Commission. But in terms of the topics for stock taking, there may be an area where I don't know how the types of situations that were being described about perhaps where we might need to strengthen existing legal frameworks to respond to the digital economy elements would fit into these categories. So I think if we need to add a category, that would be fine. If there's a way to clarify it within perhaps equality and fairness or appropriate use of dispute resolution on online platforms, I would leave it at that. Thank you.
Thank you very much, Karin, for the point you're making. And it brings me to one of the presentations where we heard the interconnection between the work that is being done in Working Group 4, Working Group 5, and here in Working Group 2. And I think that is really a value added that looking into this stock-taking exercise is going to present, is this de-siloing the work of UNCITRAL when we're looking at the digital economy. And I think that's really something that's going to be very valuable for us. So thanks for that.
Okay, I would like to go to those in the room first. On the list, Switzerland, and then followed by France, but then Switzerland first.
Thank you very much. As I said yesterday, the stock-taking exercise the Secretariat has gone through with us was an extremely useful exercise. The question now is, what do we do with this? And in particular, in the framework of UNCITRAL. There's a first possibility of making this diversity of information available to the users and including such stock-taking or the perception or the continued observation as a function of UNCITRAL. The international basis and the widespread geographical basis of UNCITRAL may justify such an exercise, but I'm not sure how that would fit in the traditional work of UNCITRAL. But it may be a question to think about. Can UNCITRAL be a sort of an observatory of developments and trends and make these the information about these development and trends available to the users of commercial law in the various fields? So that's the first basis. I'm not sure about it. I simply flag this as a possibility. The next step would be to distill from this mass of information areas where some form of action, we heard regulatory action or other action may be required, and then we will have to think, is this a type of action or regulatory action that where UNCITRAL is properly placed? And Jamie Lee yesterday reminded us of the gestation period in UNCITRAL, and with the fast-moving development in this sector, one can question whether many of these areas where protocols and other documents are developed, UNCITRAL is the right source, or whether it is not preferable for UNCITRAL to leave this to the various players in the field and perhaps be simply an observer, like, for instance, when we discuss about witness hearing and the various protocols that UNCITRAL gathers material and discusses this at a higher level, but does not attempt to have a regulatory force. And I think the third one is what some of us have touched upon already, is to examine existing texts and see what are the implications of the digital economy on our existing concepts. I can give a few examples. For instance, the place of arbitration. Is the place of arbitration still, of course, it's a legal concept which may be well adapted to the variety or the uncertainty of the players in the situation, but that's not necessarily the case. So that would be something to examine. The question of notification. When are acts properly notified, for instance, when they are placed on a platform? The question of the written form, the question of the award, the communication of the award, electronic communication, the question of the the case management system, in particular the due process aspects. I think that would be an activity which squarely falls in the traditional form of activity. And before we enlarge the possibility, we may put that to the Commission as possibilities of additional activities. I think we'll have to think both the relationship, what does the Commission itself can do in this area, and what is the Secretariat, especially with the limited resources available to them. Thank you very much.
Thank you very much. I think that's exactly the way we had approached the developments in Working Group 4 on looking at the legal issues relating to the digital economy, to digital trade. And we have approached it in the form of a taxonomy first. So we have looked at the various technologies, how they impact the way of trading, and we have then looked at the existing UNCITRAL texts, and we've looked at how do they address these new forms of transactions, or don't they? Is there a legal loophole somewhere? And I think that it would lend itself, in my view, nicely to use some similar type of methodology to look into existing texts, see how these new technologies and the application of the technologies impact, and the impact can be both disruptive or also conducive. You know, it can be a very positive impact, and see from then how the existing UNCITRAL texts deal with these disruptions, and then see and identify potentially areas where there is need for further developments, legislative developments, while at the same time monitoring all these developments that go at lightning speed as we see currently. So that's an approach we were thinking from the Secretariat point of view could be a good methodology that mirrors what you were just saying. Thank you.
Thank you. France?
Bonjour.
Yes, good morning. I would like to start by thanking the Secretariat for the work, which are very enriching. I think this work of inventorizing developments is indispensable, given how quickly practices, developments, and new practices come online. From this viewpoint, I think that we're not going to stop doing that today. We've already taken a look at the world today, which is very different from what we had yesterday. And I think what we're going to have tomorrow and the day after tomorrow will be very different still, which would mean that this work of ours of being an observatory seems necessary in as much as it's possible, given the resources available. I also think that already today we can state that the information that collected so far are very different and can give rise also to different kinds of work on behalf of UNCITRAL. There is, for example, the kind of work that seems very interesting to me and totally doable and practically very important, and it would consist of updating, as it were, the existing texts as they relate to new instruments which have been developed. There is another kind of work which would consist of wondering whether we shouldn't replace the current ways of dispute resolution with others. I'm not sure whether using algorithm instead of actual people would fit within the same notion of justice. I'm not sure that even philosophically speaking, states would be ready to agree on what their concept of justice is. I'm not sure that an agreement is possible here. So these are interesting points, and we need to be aware of these new practices. I don't know whether regulatory work by UNCITRAL here could be fruitful, though. Furthermore, the last speaker, which I found particularly interesting, on the tracing of assets and also the execution of decisions on those assets. That is very interesting. And I am saying this, of course, we need to de-silo the working groups, but I think nonetheless, as this is something that belongs better in Working Group 5, nonetheless, we need to be aware of what they're doing by us in Working Group 2, but still I think that it probably falls under the purview of Working Group 5 than Working Group 2, I think. The execution, the implementation phase, I think, is something that comes on later and deals with different issues. But once again, let me close by thanking the Secretariat for providing us with an opportunity of having this colloquium. And I think it's a very good thing for us to keep continuing with this work. Thank you.
Thank you. Next on the list is the delegate from Canada on the platform, Manon.
Bonjour à tous. Hello, everyone. I would also like to thank the Secretariat for organizing such an interesting and varied colloquium, and of special note to our colleague for Japan. I believe it was his initial idea that has led us here today. And the stock-taking exercise it's crucial. It's a very, very important step that allows us to share and learn on different approaches that have emerged in the past 2 years, especially. There are too many topics to comment on. So I will just focus. I think it would be worthwhile adding hearings and witness examination to the stock-taking exercise. And as far as format, it could result, I think, in the form of a Secretariat paper like it is. We could call it a taxonomy, like the Secretary noted earlier today. The timing, of course, I think needs to remain flexible. I feel that there's so many topics to examine. We will seek guidance, I guess, from the Secretariat on the resources and the timing of this important work. And of course, we look forward to hearing the further discussions of this week. We've learned so much already, and it's only been a day and a half, so we look forward to the rest of the week. Thank you.
Thank you. From the Secretariat, we had initially planned this as a 2-year project initially, and we'll have to see what the scope is and how we can go about it. But that is how we plan to proceed, and possibly to report back to the Commission in 2 years' time with the information that is provided in this document. If there are no other requests for the floor, are there any other requests? Yes, then I would like to make a housekeeping announcement. Tomorrow, we are organizing with another division of the Office of Legal Affairs, the General Legal Division, on the use of the expedited arbitration rules for legal advisors in different international organizations. We will have a very short presentations on the expedited arbitration rules and how they can be used by international organizations. And we'll be sharing that link with the participants through the email. It's a different link than this platform. And we are going to be holding this briefing from 9:30 to 10:30 New York time. So it's going to be quite early in the morning for New York, but we have a number of organizations that are placed in Europe, and that's why we have chosen that time. So if you would like to hear a brief introductions of the expedited arbitration rules, which was actually finalized by this working group, so you should know what the contents are. But we'd like to present that to the legal advisors and how they can possibly utilize it in disputes within the organizations and with their suppliers or any other disputes that they have. But in order to give the legal advisors a chance to ask questions, we would like to reserve the Q&A for those legal advisors. But if you'd like to have an overview, please join us, and we'll be sending you the links to this side event in due time. Another point, I know that we have tried to give you some additional seats, but it is quite packed still now. So we have asked our conference officers to allocate additional seats in between you so that you can be seated more comfortably. I'm not sure if the conference officers are able to conduct it during the lunchtime, but if you could take your belongings with you, or note that your seat might actually change after the lunch break, just be mindful of that as you go to your lunch. With that, I don't think there are any other requests for the floor, and we'd like to close the morning session, and we'll invite you to the afternoon sessions, which will actually go into a little bit more details on the use of online platforms for dispute resolution, which will start at 3 o'clock in New York. Thank you for your attention.